My name is Sapna Changiani, and I'm an advocate, arbitrator and mediator based in Singapore. It gives me great pleasure to present to you this podcast interview with Dame Geraldine Andrews. Before we start the interview, let me tell you a little bit about our guest. Dame Geraldine Andrews was called to the bar by Gray's Inn in 1981 after graduating from King's College London with a first-class degree in law and an LLM. She practised from one of the leading commercial sets in London, Essex Court Chambers, for 30 years, taking silk in 1981. Her practice had a strong international favour, and she was the first QC in 20 years to be admitted to the Bar of Singapore to argue a case in court here in around 2011. She was also a popular appointee as an arbitrator in international commercial disputes. She became a Deputy High Court judge in 2005 and was appointed as a judge of the High Court in October 2013. In October 2020, she was appointed as a Lady Justice of Appeal, sitting in both criminal and civil appeals. She has always had a strong interest in legal education, having been an advocacy trainer at the highest level since 1997, both in the UK and in many foreign jurisdictions, including Singapore. She is also the co-author of the leading practitioner's textbook, The Law of Guarantees, which I had the opportunity to read cover to cover for a case a couple of years ago, which I think slightly alarmed you, Geraldine.
Well, I thought it was a good antidote to sleeping tablets, actually, or an alternative to sleeping tablets.
So, Geraldine, can you please talk us through your decision to apply to Essex Court Chambers? They had never previously had a female tenant. Was this a daunting experience for you?
At the time, I was completely naive about it. I think it was the consequence of a combination of the self-confidence and the arrogance of youth, if you like. I went to the lady at Gray's Inn who was advising people on future career prospects. And in those days, there was only one lady. And in those days, unlike now, there wasn't a centralised application process. You did it all yourself. So I walked into her office and I said, "What is the best commercial set of chambers in London?" And her response was 4 Essex Court, which was how Essex Court Chambers was then known. And I said, "OK, that's where I'm applying." So I had to write a letter to the members of the pupillage committee. And I did it all myself. I wrote a letter, I explained about myself, and they invited me in for an interview, had the interview, and then, to my delight, a couple of weeks later, they sent me a letter offering me pupillage. And then I said, actually, I'd like to defer it for a year, please, so that I can go back to King's to do my master's degree. And it was very fortunate that I did, because they did not take on as tenants any of the pupils in that year. But they were waiting for my year, as it happened. And in my year, there was me and 4 very highly intelligent, highly qualified young men competing, as we believed at the beginning, for one tenancy. In the event, they took 3 of us, but we were not to know that at the beginning. And you might have thought that starting off, we would be, competing with each other, that there would be a degree of lack of support, maybe, competitiveness. It was absolutely the opposite. We were all very supportive of one another, and we're still friends today. Those of us who were pupils in 4 Essex, as it was. So actually the experience was not daunting. It's only when you look back.
Well, did you encounter any specific challenges at the bar related to gender bias, being a female at the commercial bar, which it's fair to say was pretty unusual in those days?
It was, because there were not many women senior to me at the time. There were a few, and they were universally supportive and helpful. They were in a number of different sets of chambers. One person who was particularly supportive was Rosalind Higgins, who was associated with my chambers. She was a professor at the LSE in public international law. And I think if Ros had wished to practice full time, she would have probably got a tenancy ahead of me, no doubt about it. But she was assiduous in coming over to at lunchtime to, usually she had an excuse, I want to get something from a file or a folder. But I think in retrospect, she was keeping an eye and making sure I was okay, because it was quite lonely. The only women in chambers apart from me were 3 typists, a receptionist and a VAT clerk. And indeed, we did not have a dedicated female toilet when I joined. So that was a bit daunting. But in terms of discrimination, I have often said to young women aspiring to come to the bar now that I was very lucky because I was a specialist in a specialist set. And I honestly felt that in my chambers, you could have a blue head, green hands, and speak Martian. But as long as you could do a demurrage pleading and you could advocate in court, they didn't care who you were or what your gender was, or anything else about you in your private life. I think the bias came from clients and instructing solicitors, in fact. And it was our clerks who insulated me from that. So the wonderful David Grief, who is probably known to many people listening to this podcast, David was my senior clerk. And he and his number 2, Joe Ferrigno, I think just insulated me from any discrimination and tried to make sure I was given as much opportunity to shine as the young man.
Did you face any challenges in court?
No. In the commercial court, I was treated by the judges in exactly the same way as any other advocate. Outside of the commercial court, because I had a fairly chancery slant to my practice, there were 1 or 2, shall we say, more old-fashioned judges who had a reputation for a degree of misogyny, shall we say. But to be honest, I think on the whole, I ignored it and just got on with the job. And once you established a reputation for being a good cross-examiner, someone who didn't waste time in court, someone who was always well prepared, then I think that won the round. I personally had very little trouble with opponents, with judges, or indeed with colleagues. And Chambers was always a very happy place to be in. I was sad to leave it, in fact. I had a great time there. And it was nice to be able to welcome other women when they joined. Although that was some time in the future. I was on my own for 4 years before the next female tenant.
There's lots of women now.
There are. It's completely transformed. It happened when David Foxton, who is now Mr. Justice Foxton, took over as head of Chambers. And David made a concerted effort to try and encourage more female practitioners, because Chambers had lost not just me, but Sarah Cockerell, one of our other female silks, who's Mrs. Justice Cockerell now in the Commercial Court, within a fairly short space of time. And there were only, I think, then 2 female silks remaining, one of whom was only newly appointed. And so it was thought that it would be good to encourage more women to apply. We had plenty of young women at the lower end of Chambers who were coming in, but not enough seniors. And now the balance is really good.
Can you tell us about your connection with Singapore, please, and how it came to be that you found yourself arguing a case in the Singapore court?
Well, my connection with Singapore goes back a long way, because my pupil master, Mark Saville, who wrote the 1996 Arbitration Act when he became a judge, Mark had great connections with the Far East and with Singapore in particular. And he got a lot of work from the law firms here. So when I was working with him as a very junior counsel, I got to know a lot of the younger associates in some of the big law firms, Lee and Lee in particular, and Allen and Gledhill. When Mark became a judge, which was not that long after I joined Chambers, much of his work went to John Thomas. And it sounds probably, Sattler, as if I'm name-dropping all over the place, because you know and I know that John became the Lord Chief Justice eventually, but in those days he was just plain John Thomas QC. And he inherited a lot of Mark's work and had his own links with Singapore. And my first encounter with Singapore itself was as John's junior in a big civil fraud case in 1993, when John was instructed and somebody had to go through all the material. I think that there was a room full of boxes of papers, whole room full, and produce a schedule to try and make sense of what had gone wrong with this company. And so the idea was that it would be cheaper than instructing a firm of forensic accountants to send me out to Singapore to work with the young associate in the law firm, Marina Chin, now one of the senior partners at TKQP. And together I was supposed to be assisting Marina in how one sort of got through this sort of material. So I came over and then discovered that there had been a slight misunderstanding with the visa with the immigration people, and that I could not in fact work in Singapore as was originally intended. So the compromise that was reached was that at weekends I'd be a tourist and I'd stay in the Shangri-La. And then on Monday mornings, a fleet of cars would arrive outside of the hotel with all the boxes of files. And we would solemnly drive across the causeway to Johor Bahru. And we would go to the Puteri Pan Pacific Hotel, where Marina and I would then be put up for the whole week, and we would work as if it were an office. And we would work really, really hard. We exhausted the charms of Johor Bahru fairly quickly, I should tell you. But we did that, and then we were let out to play at weekends. And this went on for, I think it was the best part of 4 weeks, until I had cracked the schedule. But as a result of it, we managed to produce a document. We did the pleadings. And we produced a document which convinced the other side that we were going to be able to prove fraud, and they settled the case. So we didn't ever get to court. And John was already geared up to go and argue, because in those days silks were more readily admitted. But he didn't need to because of all the hard work we'd put in. So that was my first encounter with Singapore.
When was that? Do you remember?
1993. I remember it very well because I was allowed to bring someone with me to keep me company, and I took my niece, who's now a partner in the derivatives department of Clifford Chance, but in those days, aged 19, having not yet been to university, but studying law. And she had a wonderful time. She spent quite a lot of time getting to know Singapore, and I should say is as much a fan of Singapore as I am. So we have been here together since, and last year she brought her husband for the first time to Singapore. So
a wonderful long connection with Singapore. And that led to you being involved in Singapore work and your ad hoc admission to argue a case.
Well, I was doing a lot of work behind the scenes while I was still a junior. But of course, I was advising. As soon as I became a QC, there was then the opportunity to travel out here to advise, but still you didn't get the opportunity to appear in court. I did appear in one or two arbitrations, indeed in this very building. But what happened was that the case involved two men who had been in a joint venture partnership together. And my client discovered that his friend and business partner had been cheating him of dividends. But when the friend was rumbled, he very cleverly and cunningly went round all of the firms in Singapore and got an opinion from them so as to conflict my client from getting a senior counsel. And all the senior counsel on Singapore were conflicted apart from one who was a professor of law at NUS, but who had not a lot of courtroom experience. And so initially he was going to argue the case, and I think for one reason or another he couldn't. He may even have been appointed to the bench at that time. I know he later was. My client was effectively stuck, and he was up against Raja and Tan, all guns blazing. So it was decided to take the risk of making the application. And the judge was V.K. Raja in those days, and he was sympathetic. But the Attorney General nevertheless opposed my admission, and it resulted in a 40-page judgment, which is still out there to read. But I came, I argued the case. We won it in part and lost it in part, and then appealed. And by the time of the appeal, I was already appointed to the bench, and so my colleague and co-author Richard Millett, King's Counsel, Richard came out and was admitted to do the appeal, which I'm happy to say we won. So justice triumphed in the end, and we got the client a really good result.
Can you tell us a little bit about your career as an arbitrator and how it compares to your career as a judge at first instance and most recently as a judge of appeal?
I think the more direct comparison is with being a judge of first instance, although quite often as an arbitrator, I sat with two other arbitrators. So in that sense, it's similar to an appeal court. I was lucky enough on a number of occasions to sit with retired commercial judges, and that was a good experience. I was most often appointed by the London Court of International Arbitration, once or twice by the ICC. On the, I think, 2 occasions I was appointed here by SIAC, the cases settled before I got to hear any submissions. But it's not a dissimilar process to the process of being a judge. You have to sit there and listen to the case being presented, resist the temptation to interfere and take over the cross-examination yourself, and make up your mind, which for an advocate is quite an alien thing because you are used to presenting the arguments, aren't you?
Have you had any experience of mediation?
Yes. I'm not a trained mediator because I know myself well enough to know I wouldn't be much good at it. It's a very special skill. And when you have the privilege of being in a mediation with somebody who really knows what they're doing, there's a well-known international mediator called Michel Kalipatis, KC. Michel is, without doubt, I think, one of the best around. And he just has this wonderful facility of bringing people together. I did a mediation before Michel, obviously very confidential, so I can't go into the details of what it was about. But I remember that the tension in the room at the beginning of the mediation was really high. And the other side's chief executive officer was purple in the face with indignation about the claim we had made against him and his fellow directors. And the mediator just took all that tension away. And about halfway through the day, he called me and my opposing counsel, who I knew very well too, into a room together to just discuss the possible way in which there might be a way through to settlement. And he then brought in the two CEOs to have a discussion. And I can remember the moment when one of them turned to the other and said, "What counsel has just said makes a great deal of sense to me in terms of the commercial negotiation. Make me an offer." And that was the breakthrough. And at the end of the day, when we'd signed off on the deal, everybody was shaking hands and smiling, and there were lots of plans to meet up, and it was just a complete transformation as a result of one day's very hard work. So when it works very well.
So now on to our quick fire round. What is the best advice you have ever received?
Be yourself.
I could not agree with that advice more.
No, I'm sure you couldn't.
What is the worst advice you ever received?
The worst advice I ever received was from a fellow young barrister who met me outside Lloyd's Bank in the Strand in 1981 and said, "Don't apply to 4 Essex Court, they will never take on a woman." I said, "Wait and see."
What top 3 tips would you give to younger female advocates, other than to ignore people who tell you that you won't succeed?
I don't think that happens quite so much these days. I think the tips I would give would be the tips I would give to any advocate, regardless of gender, to be honest with you, Sattler. Don't be afraid to ask for help or advice. The structure of chambers is such that usually senior people have been there, done that, and as long as they are not head down in a set of papers and so focused that they've got to do something, they will normally make time for you. And it is far better to go and see somebody and say, "I'm not sure about this. What would you do?" Funnily enough, even when I was a SILC, there were other members of chambers whose views I respected, and I would go and use them as a sounding board. So don't be afraid to ask is the first one. As to the second, cases are won by thorough preparation. There is no winging it. You have to put in the spade work. And it is very important that you have complete mastery of your material when you go into court. Because if you don't, the judge will have done a lot of hard work and you may get caught out. And once the judge thinks that you are not fully prepared, he or she will lose confidence in you as an advocate. And you have to build up that rapport of trust with the bench. And so that is very important. So you've got to put in the graft. The third top tip is you should always prepare with the end objective in mind. So the first thing you write down in counsel's notebook is a draft of your closing speech, regardless of what type of case it is, even if it's an interim application. What is it I want to achieve at the end of this application or at the end of this trial? And you might put it down in an unfocused way to start with, but you then work backwards. And you always work backwards from that to say, how can I get from where I am here to where I want to be? And that way you don't end up with what a very great trainer named James Hunt used to describe as Christopher Columbus advocacy. Have you heard of that, Sapna?
From you, Geraldine.
Yes. Well, we know a few things about Christopher Columbus. When he set off, he didn't know where he was going. When he got there, he didn't know where he was. When he came back, he didn't know where he had been. And he did it all at somebody else's expense. And what you really want to do is to avoid being a Christopher Columbus advocate. If you work backwards, you'll always avoid that.
Thank you. Great tips for advocates at any stage of their career. Final question, Geraldine. If you could start your career again, what would you do differently?
The honest answer is nothing. I've thought about this, and I don't think that I would have changed anything about being at the bar. Maybe I would have been a little bolder in advertising myself, but when I started, you weren't allowed to even have a card, which was terribly embarrassing when you came out to Singapore and everybody gave you their business card. But you had to explain, I'm not allowed to have it. It's seen by my regulator as being advertising, and we're not allowed to do that. Well, now perhaps the circle has gone a bit too far the other way with sort of corporate type hospitality to clients. But I think that maybe my male colleagues were a little more disinhibited about going out and instructing solicitors how wonderful they are. And I think I wouldn't say it's a problem that women suffer from, but I think it is something that in general is ingrained in our natures. We tend to believe as females, don't we, that if we can do something well, it will show. And we don't need to shout about it. And that reputations are grown on the back of what you've done. And I don't know about you, Sapna, but it's sort of alien to my whole nature to go out and say, look at me, I'm wonderful. I've done all these wonderful cases, and filling in all the stuff in the bar directories. I used to find anathema, which was probably why I never ended up in the sort of top clutch, even in my field. But the people who instructed me knew, and therefore they were loyal. But a lot of my colleagues were totally shameless about the sort of shaky hands and schmoozing with solicitors and clients. And I think that maybe I would have had to give myself a bit of a kick to make me more proactive.
Your career does not appear to have suffered at all as a result. Geraldine, thank you so much for spending this morning with us. during your time off in Singapore. It's been wonderful having this conversation with you, and I hope you enjoy the rest of your trip.
Sapna, it's been an absolute pleasure, and it's always a delight to come to Singapore and especially to see you. So I'm delighted that you asked me to do this.